To welcome all of you to today's presentation on employee accommodations under the ADA, with a special focus on the deaf, the hard of hearing, and the blind communities. Our primary audience today are HR specialists and in-house counsel attorneys involved to some degree in employment matters at their firms. So many of you are from among our current clients all over the United States, but we also have lots of newcomers from outside of our clientele, and we'd like to welcome all of you very, very warmly. So my name is Adam Karish, and I am the Chief Executive Officer at Karish.com. Our firm has its headquarters in the Philadelphia area, and we conduct hundreds of remote accessibility service sessions every week. We have been serving the community for over 40 years now, and we have clients in all 50 states in varying industries. And with our 24/7 in-house tech support, our team is truly made up of experts in accessibility services and remote solutions for ADA accommodations, and in particular for the deaf, the hard of hearing, and the visually impaired communities. And I am joined today by Michael Torsha, Esquire, and he's an experienced employment attorney and a presenter. Michael, why don't you introduce yourself briefly, please?
Hello, everyone. My name is Mike Torsha. I'm a managing member of Seminoff, Ormsby, Greenberg, and Torsha, a law firm outside of Philadelphia. Happy to be here today. I've been a labor and employment attorney for nearly 30 years and very familiar with some of the topics we'll be talking about today. So happy to share them with you.
It's great to have you with us here, Mike, presenting. So a little bit about today's presentation before we get started. So with Mike's help, we're going to highlight legal liabilities by using legal case studies resulting from the ADA law in employment. And the case studies that we'll be talking about will be focusing specifically on the deaf and the hard of hearing and blind communities. But we'll also be presenting on the other end how to navigate avoiding these potential legal liabilities with practical solutions. And what you might find interesting is that this event is part of a series titled ADA Compliance in Practice, and the series is focused on the relevance of ADA law for the deaf, the hard of hearing, and the blind. And each session will showcase the legal and practical implications of individual ADA law titles. And today's meeting, of course, will be covering Title I in particular. At the end of the presentation, we'll have a Q&A session. We hope that all of you will engage with us for that. But if you have any questions during our presentation, please feel free to ask them in the chat box off to the side or at the bottom of your screen, and we'll do our best to get to your questions. We'll also be muting your mics to avoid any distraction with other participants, but your chat box function will remain active, so please go ahead and use it. Mike, why don't you take it from here with the first slides?
All right, so we're going to talk about the ADA, the legal aspects of the ADA for a little bit. Some of you may know some of this, some of you may not. I think you'll find that the ADA might be a little more complicated than you might think, unless you work with it all the time. So let's start off with big picture, the ADA overview. So the ADA, the American with Disabilities Act, is a federal law that was passed in 1990. It has evolved over the years, but in 2008, there was an amendment, the ADA Amendment Act. Some people call it the ADA-AA, although it's a little cumbersome there. But what the Amendment Act did was broaden the scope of the ADA. So the ADA defines what a disability is, and we're going to talk about that in just a few minutes. But the Amendment Act broadened that definition so that many, many more people now fall under the ADA or potentially fall under the ADA. The statute itself has many sections, but is divided into 5 primary sections. And as Adam mentioned, we're going to be talking about Title I today, which is particularly employment provision. So this consists of rules, regulations, and policies for employers and employees. Literally yesterday, Adam and I gave a presentation on Title III for public accommodations, and we'll be repeating that next month if you're interested in the public accommodations presentation. So this is Title I employment. The first thing you need to know is that the ADA does not apply to every employer. Most federal statutes have certain definitions of what an employer is, and many of them are defined by how many employees they have. So the ADA only applies to employers with 15 or more employees. The way you count that is here in the second paragraph here. You count it as if it has 15 or more employees for each working day in each of 20 or more calendar weeks in a current or preceding calendar year. Okay, got that? But basically, the point of that is, and as Adam said, this is available to you later, so you don't have to furiously scribble notes here. That's why we give it to you later. The point here is, if you're a small business with 14 employees and you hire your 15th employee today, you are not automatically now subject to the ADA. It's not a hair trigger requirement like that. You have time to get up and running for the ADA. The other thing is, if you do have less than 15 and the ADA does not apply directly to you, there are state and local laws that may apply. There are many states that have state statutes that prevent discrimination against people with disabilities, Pennsylvania being one of them. That's where we're sitting right now. It's where I'm sitting right now. So as an example, in Pennsylvania, if you're a small business, you're under 15, they have the Pennsylvania Human Relations Act, which applies if you are 4 or more employees. So 4 or more, you are subject to the state law. So most people think, well, the ADA applies to someone with a disability. Yes, it does, but there are lots of qualifications to that definition. So you really have to be very specific about, does the ADA even apply to an employee with a particular disability? Yes, the ADA prohibits employers from discriminating against a qualified individual with a disability. And this goes towards all employment decisions, hiring, firing, and other employment decisions, such as it could be someone getting a raise or a promotion or a certain assignment or whatever it may be. The employer is required to make a reasonable accommodation. Sure, you've heard that phrase before. That's a fairly typical phrase. To the employee's known physical or mental disabilities. So you have to provide an accommodation unless it would impose an undue hardship upon you, the employer, or pose a direct threat to the health and safety of the employee or others in the workplace. So right away you see, yes, you have to provide an accommodation, but there are exceptions. We'll get into that in a second. You notice that it said an employee who is a qualified individual. Almost every word in this statute in the ADA has some other meaning, some broader meaning. So what is a qualified individual with a disability? Well, it's not just a person with a disability. Someone has to be qualified. So it's a person who, with an accommodation, can perform the essential functions of the job. And you might say, oh, well, thank you, Congress, for that clarification. So they have to be able to perform the essential functions. Well, first of all, what falls under the definition of just disability? Under the ADA, as you see here down below, the 3 red squares, the little bullet points there. Disability means having a physical or mental impairment, which substantially limits one or more major life activities. So you can tell every time we have a slide here that's either in red or black, that that's another definition that further, goes one step further about trying to figure out whether someone is really subject to the ADA, or someone has a record of an impairment, they have a history, or they're regarded as having such an impairment. I want to pause on that for a minute because that's really important, especially in this COVID environment and coronavirus world here that we're all in. So think about what that says, that last line in the slide, that the ADA protects people who have a disability, but it also protects people who are regarded as having a disability, or sometimes the courts say perceived as having a disability. That means that someone who does not actually have a disability, but is treated as if they do, is protected by the ADA. And we're starting to see cases like that with coronavirus. that we don't really know if someone with coronavirus has a disability. It kind of depends on the person, and it kind of depends on how it hits them, and how it affected them. But if an employer says, well, you have coronavirus and we're concerned because you're going to bring that in, you're fired. Well, whether or not that person has a disability under the ADA doesn't matter. The employer is now regarding them or perceiving them as having a disability, and that could be an ADA violation. So just keep that in mind, that someone who may not have a disability still is protected. So what's a major life activity? And I will tell you, without reading to you all these bullet points, it's almost anything. I mean, it really is almost anything, as you can see from some of these examples. So if someone has a medical condition that impairs, one or more, doesn't have to be multiple, one or more major life activities: walking, thinking, standing, breathing, eating. I mean, almost anything that you do could be considered a major life activity. Not only that, but that amendment that I talked about a minute ago in 2008, that broadened the scope of major life activities. So Congress said, in case you weren't sure that it's covered, I mean, just go back to that slide for a second, the other one. It's hard to imagine something that's not covered by one of those things. But okay, Congress said, we're going to make sure that you understand what a major life activity is. Now we're going to cover major bodily functions, which is any of these areas. So if an employee is affected by any of these areas, that's considered to be a major bodily function, a major life activity, and it's a disability under the ADA. What's interesting about figuring out whether someone has a disability or not is that the employer must ignore mitigating measures. So in other words, if someone takes medication, or they have some sort of equipment or appliance, or if they use technology or they use auxiliary aids and services, keep that phrase in mind. We're going to be talking about auxiliary aids and services in just a few minutes. You must ignore that. So if someone is hearing impaired and they have a hearing aid, or they use special technology to assist them to hear better or to interpret something they may not be able to do without any assistance, that does not mean that they are not disabled. They're still disabled. You have to ignore what employees or people use, generally speaking. So someone might have heart disease, but they take medication and they don't have symptoms. They're still disabled under the ADA, even though they quote unquote fix it with medication or some other, again, some sort of assistance or appliance or device. Except for eyeglasses, that doesn't count. Congress said that's too far. That was too far for Congress. Eyeglasses don't count. If we count eyeglasses, then everybody will be subject to it, and that doesn't count. All right. So reasonable accommodation. You've heard these terms before. What does it mean to provide a reasonable accommodation? Well, a reasonable accommodation can be any change in the way that work is usually performed. So, examples. Employee comes to you and says, I need a leave of absence beyond what I'm given by your policies, or beyond what I'm able to get from the FMLA, as an example. I might need some time off. Now, indefinite leave of absence is not reasonable, but if an employee says, I need an extra few days, I need a week, I need 2 weeks, what is reasonable? And it could change in every situation. By the way, I mentioned the FMLA, which I'm not going to get into in any detail, but just realize that the ADA covers employers who have 15 or more employees. The FMLA applies to employers with 50 or more employees. So there's two different levels there of what applies. You could definitely have the ADA apply to your business and not the FMLA. What about working from home? Employee says, I'd like to work from home. Well, back in the old days, February of 2020, before COVID, that was a conversation. Well, can you really work from home? Is it an undue hardship? How are we going to, keep our eye on you? Can you really get as much done? Some jobs you cannot work from home, obviously. If you're working on an assembly line, you can't work from home. But those jobs a lot of office jobs that you can do from home, we think going forward, we the employment lawyers going forward, it's going to be very difficult to argue that someone can't work from home when we've all been working from home for the last, it's coming up on a year at this point. Modifying a schedule, providing assistive devices, or modifying workspaces are all other examples of reasonable accommodations. Again, you have to provide these accommodations unless there's an undue hardship or a safety threat. Undue hardship is harder to meet than you might think. It's very common for employers to say, "Oh yeah, this is definitely an undue hardship. We can't let someone work from home, or we can't change their schedule, or if we let them, not do this particular type of job, the other employees are going to have to pick up those duties, and that's not fair to them." Well, if someone raised that claim and it ever got to court, you'll see that there's lots of cases out there, and we're going to talk about some case studies a little later, but there's lots of cases out there that say, you have to take into consideration the size of the employer, the size of their budget, the effect of providing this accommodation on the company. Are you going to lose profits? Are you going to maybe go out of business? Is it really going to have an impact on your business in a significant way? It can't just be annoying. That's not the standard. What's the type of operation? How are people paid? What's the nature? What's the cost of the accommodation? Is it a direct threat? Is it a safety threat to someone else or to the employee? But the bottom bullet point there comes up very often. The court will not consider the fairness to other employees. So if you say, we're not giving you an accommodation, Sally, because it's not fair to your coworkers to have to pick up your job, sorry, that's not enough. That's not considered to be an undue hardship. It's also not an undue hardship to say to an employee, that's not in our policy. Someone says, well, I'd like to work from home. We say, well, no, our work from home policy doesn't allow someone like you to work from home. That's the point. That's the point, that the ADA requires employers to do things they otherwise wouldn't do, or they otherwise wouldn't provide to the employee. We know it's not your policy. The ADA would say, we know it's not your policy. We're telling you need to do something special for someone who has a disability. So saying it's not within your policy is not a good reason to deny an accommodation. To say, what else have we heard? Oh, we've never done it before. We've never done this before. We haven't done it for anybody. Okay, well, you may have to do it now because you have a disabled employee. If you've never done it for other disabled employees, that might be a problem. You might have been violating the ADA all that time. So all of that verbiage here, let's keep it simple. Let's just boil it down to two basic things you really need to do, and forget about all the definitions for a minute. First, the employer must engage in what's called the interactive process. Second, you must actually provide a reasonable accommodation, unless there's an exception, the undue hardship or a safety threat. So what's that mean? The interactive process is exactly like it sounds. It is interactive between the employer and the employee. So Sally comes to you and says, I have this medical condition, and I really would like you to put me in a totally different workspace so I'm away from everyone else. And you, as the employer, say, well, no, we're not going to do that. Denied. That's not interactive. That's refusal. That's denial. You might even be right. That that's not a reasonable accommodation. But you must do more than that. You must engage in the interactive process. So what you must do is say to Sally, we don't think that's reasonable to put you in a totally different area. We really don't have another area, but let's talk about some alternatives. Maybe what we could do is alter your work schedule, or maybe what we could do is, have you work from home for a couple of days and then come in different hours, and you go back and forth, which, by the way, I strongly recommend you document that process of that interactive process. Hopefully you come to an agreement. If you don't, you don't. But you do have the responsibility to actually provide an accommodation after that. But if it's not reasonable, you don't have to provide it. There's a case out there that where an employee, I know this is going to sound crazy, but an employee asked the employer to buy a building, to buy a separate location because she thought that she had the right to work alone in this building. And the employer said, no, we are not obligated to buy a separate building, to put you in. That's not reasonable by any by any stretch. All right, and then I'll talk about one more thing, and I'll let Adam take it from there after this. So let's talk about penalties. Yeah, okay. We know the ADA requires all these things. The ADA requires you to engage in the interactive process and to provide the accommodation. But what if you don't, right? What if you don't? Well, if you don't, you're likely to get, and maybe you've seen these, you're likely to get a demand letter from an attorney representing the employee. You're likely to get maybe a claim that's been filed in the state Human Relations Commission, or whatever your state's equivalent of the Human Relations Commission is. Some states don't have them, but most do. And if it went to court, then the employee would be able to get back pay and front pay. Now, back pay is, let's say you go to trial and the jury makes a decision for the employee, or a judge makes a decision. Usually it's a jury. Back pay is from the time of that decision back to the time that they were terminated, or back to the time that they left the company. So they get all that retroactive back pay. Front pay, you'll like this. Front pay is from the time of the decision going forward, so that they get paid in the future. And you might say, well, okay, well, how long? How long in the future? 6 months, a year, 2 years? Well, the answer is ask the jury. They will decide how long it goes in front pay. Now, it has to be reasonable, but there have been situations where people have been terminated at age 59, that they're not able to find a job, and the jury says, well, they would have retired at age 65. We're going to give them 6 years of front pay. Whoa, that's a bad day for the employer. They can award emotional distress damages, punitive damages, which are punishment damages, and then attorney's fees. They're the employee's attorney's fees. Nothing worse than losing a trial and having to pay the other guy's attorney. That doesn't feel good. And then you're paying your own attorney's fees, of course. And ironically, after all of this, you might be ordered to provide the accommodation in the first place that caused all of this. So there are definitely serious penalties for violating it. That's why we say try to work it out, try to come to some sort of agreement. You really don't want to have to deal with an ADA claim. So I mentioned auxiliary services, aids and services, and let me turn it over to Adam to explain a little bit more about what those are.
Thanks, Mike. Thanks a lot. Right. So let me preface this section by emphasizing that Title I accommodations are equally as relevant to on-site recruitment and employment encounters as they are to online or remote settings and encounters with candidates or potential employees. As we'll discuss in the particular case studies coming up, the employer's responsibilities include, but are not limited to, the interview and evaluation process, as well as internal meetings and encounters for the duration of employment. So what you have to remember moving forward in your evaluation is that upon a specific request by an individual who's unable to access specific content, your institution, the employer, is obliged to provide accommodations. For example, any new video or audio content produced and posted on official channels, such as the company's website, official Facebook, LinkedIn, YouTube, Vimeo, SoundCloud channels, etc. All live events, including content and events that are live streamed over the internet, like announcements and presentations or any other event of high interest. And in this COVID-19 reality that we're in, keep accommodations in mind for pre-recorded materials as well. So tutorials or training sessions, etc. Now, regarding the legacy content that was recorded prior to you're encountered with this, with the person with disabilities, you may not, your company or you as an employer may not be bound to making legacy content fully accessible in your specific case, but you have to keep in mind that this might be something that you'll have to take into consideration if you conduct an internal accessibility audit, for example, and you want to fix all of the elements going on in your firm. So this whole section may have raised a lot of questions for you. Mike has definitely touched on a lot of different issues that'll raise questions, but don't worry, we'll be digging into the details of these cases and a little bit of what I said in the case studies section of this webinar that's coming up. Examples for, the ADA law stipulates a specific list of auxiliary aids and services, as they're called. We refer to them as accommodations as well. So the federal regulation proposes a long list of very specific accommodations. But that list includes, in some cases, arcane and outdated recommendations, such as telephone handset amplifiers, or simply, and I'm quoting here, exchanging of written notes. Several, though, on the list are mainstream, they're very popular, and they're used commonly in corporations, board meetings, training sessions, and also in educational settings throughout the United States and by US-owned corporations that are active abroad. So here in this upcoming session, the upcoming 4 or 5 slides, we'll be outlining 4 of the most universal solutions that are most often provided on-site as well as remotely. So let me emphasize that based on our experience with ADA compliance accommodations for businesses in all 50 states and active abroad, all these examples are equally relevant solutions for you on-site with your employment encounters, as well as in remote scenarios. So what we've done is we've broken these services into bundles or groups, and there are 4 of them that we're going to be presenting here. The first is real-time captioning. The second is transcription and note-taking. So that's primarily for pre-recorded audio files. So the third is qualified interpreters, on-site and remote. And the fourth is dedicated services for the blind, the visually impaired. So in the first section, the real-time captioning bundle or basket, it's otherwise referred to as CART captioning. CART captioning is perhaps the most ubiquitous and inclusive accommodation for the deaf and the hard of hearing communities during live events such as interviews, team or board meetings, and presentations. So CART is an acronym, and it stands for Communication Access Real-Time Translation. And it's the process of turning the spoken word into captioned text. So CART is provided in real time for an individual or for a group of really any size or any setting. And the speaker's audio is transmitted from a microphone to our certified captioner, and it's displayed as text on a large screen or monitor or the laptop computer of the person who needs it, with 98% accuracy. And all this happens within 2 or 4 seconds, 2 to 4 seconds, as you're seeing on the screen now if you're watching the closed captions. So within real-time captioning, we also include internet captioning and live streaming for live-streamed events that are posted on the internet or taking place virtually, uploaded videos that stream on sites, like LinkedIn or Facebook, YouTube, etc. We also have a service called Meaning for Meaning captioning in the same category. Now, this is real-time conversion of speech, but it's into summarized text for individual viewers. So this service is most often provided in meetings or appointments, as well as in an educational context. For example, in staff training sessions, etc. You may have heard of Typewell or Cprint, and they refer to a software that meaning for meaning is provided in. So in terms of the end user's experience, they are identical to one another. You may have also heard of broadcast captioning, which also requires a specialized type of software and exceptional skills on behalf of the captioner. We most often use broadcast captioners for TV programs, large scale public events, or simply if a client requests it. The second category that we'll be talking about is for pre-recorded audio files. So here you have transcription, note-taking, or offline captioning. So transcription is very basically the creation of 100% accurate transcript from pre-recorded audio or video files. Note-taking, on the other hand, is a little bit like meaning for meaning, and it's very popular in corporate settings. It's the process of taking verbatim or summarized text from meetings or presentations and presenting them in some type of a readable format. And when it comes to note-taking, there are really myriad formats, levels of accuracy, turnaround times, all different types of available solutions. It really depends on the individual needs of the end users. We've got offline captioning and open captioning. Offline captioning is basically closed captioning for pre-recorded materials, and it's used for broadcast or internet videos. The captions for these can be turned off, hence the name offline or closed captions. Opening captions is similar to closed captions, and the difference is that the captions cannot be turned off. So these are often referred to as subtitles. In our third basket here, we've got qualified interpreters, and this is for on-site or remote. So what we've put into this basket for you is American Sign Language, like you're viewing today. ASL can be provided on-site or remotely for business meetings, lecture halls, live events, training sessions, etc. You want to be careful to only permit trained and certified ASL interpreters to cover meetings. That's the only way to ensure that you get the best real-time service available. Another service in this basket is tactile ASL or tactile signing. Tactile signing refers to signing using touch, and it is really a common means of communication among people with deafblindness. And it's based on sign language and or some other system of manual communication. What the fourth basket that we'll be looking at is dedicated services for the blind, the visually impaired. And one of those is real-time Braille cart. And what we call Braille cart is provided, again, by a certified expert cart captioner who then connects to the blind individual's Braille reader. And this allows the end user to interact in real time in basically any environment. It's worth noting that real-time Braille cart is not a fully remote service, so it may not be applicable to all cases in today's day and age. Then we have audio description, and that is an interesting service as well for visually impaired individuals, which is the process of narrating the actions and events that take place in a video or during a live event. So until COVID-19 restrictions struck, we were providing this service for training seminars, for plays and theatrical productions. Currently, it's primarily ordered for pre-recorded materials rather than for live events, but that doesn't mean that it can't be used for live events. Now, so I think at this point, Mike, I'm going to have to hand it back over to you, and you'll walk us through the case studies.
All right, I shall do that. We have a couple of cases to illustrate some of these points. Before I just jump into the case studies, I will make a general comment, on some of the services that Adam talked about. One of the things we're seeing that's been happening for many years now are attorneys and law firms that are attacking industries because websites are not accessible to especially those who are sight impaired and blind. And what I mean by that is they're filing lawsuits against it could be the banking industry, it could be retail stores with online shopping, and it could be law firms. So anyone who has a website that is designed for the public to view, if that's not accessible to the blind, as an example, then you may get hit by one of these class action lawsuits and be brought in on these things. So what you have to do is have your website reviewed and made accessible. And that's part of an overall sort of accessibility audit that you do with your own business. Kind of getting back to the employee-employer, Title I issue, though, two case studies here. The first one is interesting, is Knoll versus International Business Machines, IBM. So Knoll versus IBM. In this case, the plaintiff, the employee, was a deaf software engineer who worked many years for IBM. He was provided with ASL interpreters, American Sign Language interpreters, whenever he wanted for meetings and video content, as well as CART. So let's just stop there for a minute. IBM was providing this employee with any accommodation that he had requested so far. So they knew their responsibility, and they were providing it for many, many years. At some point, Mr. Knoll demanded that all of the intranet videos be captioned and all audio files have transcripts. So IBM had a huge library of all sorts of videos, training videos, meetings, things like that. And he wanted the company to go back and caption all of them and have all audio files have transcripts. The company refused, and he brought a lawsuit, and it went to court. And at the trial court, it was decided in favor of IBM. So the plaintiff then appealed from the trial court in federal court to the Court of Appeals, in this case, the Second Circuit, which is like the New York area, among other states. The Court of Appeals affirmed the trial court. They agreed with the trial court, and they said that ASL interpreters and CART were reasonable. They were reasonable accommodations. But requiring the company to caption all videos and provide transcripts to all audio files was unreasonable. And the reason it was unreasonable, and this is an interesting case, if you look at the second bullet point there, it was unreasonable because there were 46,000 of them. There were 46,000 video files and 35,000 audio files. And the court said, even for a company the size of IBM, the first bullet point, even if the company has 440,000 employees and however much revenue it had, and obviously an international company, it was unreasonable and undue hardship to go back and have to do that for all of the video files and all of the audio files. It may not have been unreasonable to provide transcripts. Just going back to this one for a minute. Remember, he wanted to caption videos and provide transcripts for audio files. It may not have been unreasonable to do that for particular videos or audio files that he wanted to have access to. So upon request, then the company would have to do it, but not just go back and provide it. What was interesting is that one of the judges, the Court of Appeals was a 3-judge panel. One of the judges said, you know what, we the judges, we really shouldn't be deciding this. We should be letting the jury decide what's reasonable. Let it go back and have the jury decide, but that's not ultimately was done. That judge was outvoted. This is case study number 2. Before we get to case study number 2, I just want to mention one other case that came up that's pretty interesting. Not an employee case per se, but very timely. So there's a case called Kane, K-A-N-E, Kane versus Zoom. Yes, Zoom, exactly what we're on, the platform. And this case was filed about a month ago, December 18th of 2020, it was filed. And it's a class action lawsuit against the Zoom company because Zoom provides this service that we're all on, but in order to have it captioned, they charge a premium. They charge extra. And the class action lawsuit is to make the point that it should not be more expensive to provide a service like this for hearing impaired. That case was filed in New York, in the federal court, Eastern District of New York. So we'll see what happens with that. There hasn't even been a response, I don't believe, by Zoom yet. But that just kind of goes to show you how some of these lawsuits have been developing. You know, if there's an accommodation that needs to be made, whether it's to the public or to employees, that has to be made so that everyone's on equal footing. All right. So the first case, Mr. Knoll against IBM. A single person against the company, kind of a private lawsuit there. The second one is not a private lawsuit. So if there is a claim by employees, you remember I said a few minutes ago, that someone could bring a claim with the Human Relations Commission, your state's Human Relations Commission. They may also bring a claim with the federal commission, which is the EEOC, the Equal Employment Opportunity Commission. And in this case, there were two women who did just that. They brought a claim with the EEOC against this company, S&B Industry. And the EEOC decided to take up the cause and sue the company on its own behalf, on the EEOC's behalf. These women were two deaf women. They applied for jobs in the company's cell phone repair facility. They were both deaf. They applied at the same time. During the interview process, there was a group of applicants, and the two women used ASL to communicate with one another. The applicants then said to the supervisor, we need you to write out what you're telling people. We need information written out. The supervisor initially did that, but then refused to continue writing information. Now, we don't have the details on exactly what happened, but you can sort of understand or sort of, imagine the supervisor is in this group interview, has to stop and write out information. And at some point, it sounds like the supervisor said, you know what, I'm not doing this anymore, like enough. I don't think the supervisor went to human resources or the company's lawyers and said, what are my obligations? I think the supervisor basically said, enough's enough, and I'm not going to do it. The two applicants were then rejected for employment. So note that we're talking about Title I of the ADA, the employment. It also protects people who are not yet employees, right? These two women were not employees. They were applicants. So the applicants filed a claim with the EEOC, as I mentioned, which they were required to do before filing a lawsuit. In every state, you need to do something to file it before you can file a lawsuit. The EEOC then agreed to represent them in Texas federal court, and there was a settlement. There's very often settlements in these cases. Well, under the terms of the settlement, it was a 3-year consent decree. Consent decree is just, kind of fancy term for settlement agreement. A 3-year consent decree settling the case. The company agreed to settle the case and to do the following. They paid $110,000 in total monetary relief. They agreed to post a public notice about the settlement in addition to an announcement by the EEOC. The EEOC usually puts things on their website and say, we've settled the case against S&B Industry. They agreed to provide training on the ADA, especially about reasonable accommodation process. I suspect that they were given training much like you're hearing today, talking about the definition of the ADA and reasonable accommodations. They agreed to send certain managers to training provided by a Dallas organization, Deaf Action Center, and they agreed to keep a written log of all complaints of disability discrimination and report to the EEOC occasionally on what they have seen in terms of applicants for people who are otherwise disabled. So there were lots of remedies here afforded to the two women who brought the case. I don't believe that the two women were ultimately hired. I don't think that after this lawsuit they wanted to go to the company, and that was not part of the settlement. So two interesting cases: one private against a big company, one not so private with the EEOC with two applicants. And I want to talk a little bit about sort of the implication of those settlements, those two different results.
Sound is always helpful.
Yeah.
Situation like this. So very briefly, as you mentioned, Mike, after a few years of proceedings, each of the lawsuits was basically settled. But in each of the cases, we see that, you can't treat either of them really as specific precedent for other cases. Like, for example, the employers, the HR specialists that represent employers during, as attendees during today's webinar. But they do give us a useful behind the curtain look at sample situations that might be similar to ones that your institutions could find themselves in. So the silver lining to all this litigation and to the case studies, the results of the case studies that we just saw, is that selected accommodations such as CART, ASL, note-taking have really started to become standards for most employers and for their social media content that they publish, et cetera, for the employment and employment process. It's very much the same with American universities. Many employers have already realized that really the socially responsible thing to do is to preemptively run an accessibility audit, like the one that Mike was talking about earlier, to establish digital accessibility guidelines, to set captioning quality guidelines for your firm, and to continually improve accessibility of your company resources, especially for those who are deaf, hard of hearing, and blind. So really the case studies, they are fascinating and they're telling. They expose that accessibility accommodations, especially in the context of employment, don't offer a one-size-fits-all solution in any case. And oftentimes employers simply don't know what they need to do, and they're looking for experience-based guidance. And that really brings us to our next and nearly final slide about choosing your agency. So throughout the presentation, we've outlined most of the popular accommodations relevant to the deaf and hard of hearing and the blind communities. So please know that Carish provides all of these services to corporations and to law firms like yourselves, to government institutions, and to universities throughout the country every day, and we have for decades. So remember, when it comes to ADA compliance accommodations, don't wing it. Reach out to us for advice and guidance. There is no need to be apprehensive about these interactions that require accommodations, especially if you're prepared. So with the right guidance, the right advice and support, adding accommodations like card captioning or note-taking could really be a great improvement even to your organization, your entire organization, for those who are hearing and not visually impaired as well. So typically at this point, I might walk through some more practical considerations like setup and testing, or tech support and security issues, encryption, et cetera. But I'd be happy to do that offline in a separate one-to-one meeting with anybody who is interested in that kind of granular detail. And I am posting now, if you look in your chat box, I'm posting a link where you can just schedule a meeting with us for 15 to 30 minutes, and we can walk you through all the technical components of the setup and security issues and encryption. And if for whatever reason you're not able to sign up here, then please be sure to contact me via email, which you'll see on the next slide coming up. So what we're going to do now is open up for a Q&A session, and we'll ask you to share any questions that you might have in the chat box to the bottom or the side of your screen, and we'll allow a few minutes to handle those questions and try to answer them as best we can. And if we don't get to some of the questions, or you think of questions after the event, please feel free to contact Michael or myself, and we'll be happy to help you offline.
While people are thinking about it, if they have a question or not, I'll just emphasize one point about the reasonable accommodations. Again, you don't have to provide any accommodation that an employee requests. You have to provide a reasonable accommodation, but it's not usually a good idea just to refuse some accommodation. But you also don't have to just, agree to the very first thing that the employee says. You also can't, when I say the employer also cannot substitute their own belief for, you can't substitute your own belief over like a medical certification or a doctor's note, for example. So if your employee comes in with a doctor's note that says, this employee, I'm recommending that they, that they come in an hour later because of the medication they're taking, you can't say, well, I don't see how that's going to help you, or I don't really think that's going to be very beneficial to you. You can't substitute your own medical knowledge, however great you think that might be. So you can do all sorts of things. You can ask for clarification from your employee's doctor. You may even be able to send them to another medical exam if that's appropriate, if that's the kind of disability that someone has. But my message here is don't just refuse and shut down the communications. You will be very happy later that you had that interactive chat with your employee and documented that than not. There's lots and lots of cases, and we see lots of employers that get in trouble because they just refuse to have the conversation, right? Which can be frustrating, by the way, because you might have employees that ask more than once, right? You have an employee that asks for something and then a few months later may ask again, a few months later may ask again. And at some point it may start to be frustrating for those people to have to deal with it, but that's just a requirement under the ADA. Every time is like a new instance. So,
could you tell us a little bit, Mike, about what these accessibility audits entail, and what type of an employer would want to conduct such an audit, and why?
Yeah, so accessibility audits have different meanings to different employers, but from an employment perspective, there are lots of employment lawyers. You may have attorneys that represent the company now, or that you deal with, that will come in and they will literally audit your policies and procedures. When we do it, we go through and we say, let us see your handbook, let us see your policies. Okay, aside from your handbook and policies, what do you really do? And you look at all of those types of protocols and try to figure out, are there holes? Are there things that you're not doing that you need to do? Are you complying with the ADA in hiring, in promotions, in evaluations, in terminations, whatever it is? Are you complying with the FMLA? Are you complying with other statutes? So there's a policy and procedure review that is conducted that I would recommend, if you have never had that conducted, that you contact an attorney to do that at some point. I think it's very, very valuable. And then there are other types of accessibility audits, such as the physical space, where someone comes in and they look at your physical space and see if you are complying with the ADA technical requirements. So it can be one or the other or both. But on the employment side, again, if you've never had it done, I can almost guarantee there will be something. Somebody will find something that you could tighten up, or some policy or procedure that you didn't know. And that goes for all employment laws. I mean, there's ADA audits, but an employment lawyer coming in also look at your wage and hour practices. They look at your FMLA, as I mentioned. They might look at your employment contracts. They might look at your forms. So it's just an ongoing battle. And especially now with coronavirus, with the new statutes that were passed last year, the Family First Coronavirus Response Act, the FMLA has been expanded. I mean, there's all sorts of things that have just changed the landscape for HR professionals. And, if any of you are out there, HR professionals, or you're you are in charge of HR, I really sympathize with you. It's just very difficult to keep up on these things.
And could conducting an audit like that be viewed as goodwill on from the employer's side? If there were a dispute, can you put up an audit like that, hold it up to the court, and say, well, we conducted the audit and we did everything that was in the audit?
Sure. That yes, it could be. It could be. Now the flip side of that is, don't conduct an audit and find out you're doing something, very, very wrong, and then not fix it. Right. That's not going to be helpful either. But certainly, it's good faith is always a factor in lawsuits. Whether it's technically a factor, sometimes judges and juries can literally take into consideration good faith efforts. Sometimes they are not allowed to really take that into account, but they do anyway. Judges and juries, they do anyway. That's just how people think. If you're not being fair, you could do everything right, exactly right, according to the law, according to the statute. But if a jury believes that you didn't treat the employee very well or retaliated or something like that, it's going to be difficult to prevail on that claim or win that case. So I guess what you're hearing is, if it's at all possible, be nice. It's a lot less expensive than a lawsuit. All right. Well, again, as Adam said, we're happy to take questions afterwards. You have our email addresses there. If you'd like to send a question to either one of us, be happy to respond after the session.
That's right. Also, just a quick note, we will be sending out a survey to all of the attendees. So we would be really grateful if you could just take a couple minutes and answer those questions and share your thoughts or critique with us to help us improve our content for future viewers or attendees to webinars that we'll be doing in the future. So thank you so very much for attending, and we hope to hear from you soon.
Thanks.